Good afternoon. We will go on the record in CR 10-24-2407, State of Idaho versus Lance Jonathan Broncho. Are you Lance Jonathan Broncho?
Yes, ma'am.
Mr. Broncho, we are scheduled for your first appearance today on a criminal complaint that has been filed that charges 5 counts. Have you had an opportunity to see that criminal complaint?
Just recently, yes.
Okay. Would you like me to read a copy of that complaint, or would you like to waive the reading?
I'd like you to read it, please.
Okay. All right, then the criminal complaint charges you with count 1, murder with a part 1, count 2, aggravated battery with use of a deadly weapon or instrument with a part 1 also, count 3, robbery, count 4, burglary, and count 5, unlawful possession of a firearm by a convicted felon. Count 1 details that the defendant, Lance Jonathan Broncho, on or about the 9th day of March 2024 in the county of Bonneville, state of Idaho, did willfully, unlawfully, deliberately, and with malice aforethought committed in the perpetration of or attempt to perpetrate robbery, burglary, or mayhem, kill and murder Eric Leask, a human being, by shooting Eric Leask in the commission of a robbery from which he died. The maximum punishment for murder in the first degree is punishable under Idaho Code 1840-04, punishable by death, or if the death penalty is not sought, the court shall impose a life sentence with a minimum period of confinement of not less than 10 years. Additionally, a fine of up to $50,000 and an additional fine for crimes of violence of up to $5,000 pursuant to Idaho Code 1953-07, which acts as a civil judgment and restitution. That's the maximum punishment for count 1. In addition, the state, as noted, has filed a part 1 of the information, which alleges that there was the use of a deadly weapon in the commission of the crime, which increases the penalty for an additional 15 years pursuant to Idaho Code 1925-20. Count 2 states that the defendant, Lance Jonathan Broncho, on or about the 9th day of March 2024 in the county of Bonneville, state of Idaho, did unlawfully and intentionally cause bodily harm upon the person of Ormead Smith by means of a deadly weapon, to wit, a firearm. The maximum punishment for aggravated battery is under Idaho Code 18908 for up to 15 years in prison, a maximum fine of $50,000 and a civil judgment fine of up to $5,000 under Idaho Code 1953-07 in restitution. In addition, a weapons enhancement has been filed by the state in relation to this charge for use of a deadly weapon, which increases the penalty for an additional 15 years. Count 3 alleges robbery that the defendant, Lance Jonathan Broncho, on or about the 9th day of March 2024 in the county of Bonneville, state of Idaho, did intentionally and by means of force or fear take from the person of Ormead Smith and or Eric Leask personal property which was accomplished against the will of Ormead Smith and or Eric Leask, in that the defendant, by pointing a firearm at Ormead Smith and telling Ormead Smith to give him his property, to wit, a 9mm FN pistol and or wallet. The maximum punishment for count 3 for robbery is provided under Idaho Code 1865-03. It's a minimum of 5 years, up to life imprisonment, a fine of up to $50,000 fine, and a $5,000 compensatory fine as well as restitution. Count 4 alleges burglary that the defendant, Lance Jonathan Broncho, on or about the 9th day of March 2024 in the county of Bonneville, state of Idaho, did enter into a certain house, to wit, 195 East 4th Street, the property of Eric Leask, with the intent to commit the crime of robbery. That is punishable. But burglary is punishable by a minimum of 1 year up to 10 years, a maximum fine of $50,000 and restitution. Count 5 finally alleges that the defendant, Lance Jonathan Broncho, on or about the 9th day of March 2024 in the county of Bonneville, state of Idaho, did possess a firearm knowing that he had been convicted of assault resulting in serious injury, a comparable felony crime in a jurisdiction of the United States as the crime of aggravated battery enumerated in section Idaho Code 18310. That count is punishable by a maximum of 5 years and a $5,000 fine. Do Do you have any questions about the complaint?
No, ma'am.
All right. Mr. Bronco, I've been handed a notification of rights form regarding these charges. It lists all of the charges. It has check boxes and it has your signature on the last page. Did you have any question about your rights?
No.
No? All right. I've also been handed a request for a public defender or to have an attorney appointed at public expense. You are not currently employed, is that correct?
No.
All right, based upon your application, I do find that you qualify for the public defender, and I will sign the order granting you a court-appointed attorney at public expense. We have Mr. Crane from the public defender's office here in the courtroom. We also have Mr. Archibald, who is present as well. So they will be representing you. I've also been handed a no contact order regarding individuals who are listed, I think, in the affidavit of probable cause, and it's my intention to sign that no contact order. Is there any concerns with that, counsel?
Not today, Your Honor.
All right. Finally, we need to set this for a preliminary hearing, and then I'll hear discussions on bond. Madam Clerk, what date do we have for the preliminary hearing?
March 29th at 1 o'clock.
Your preliminary hearing will be March 29th at 1 o'clock. The previous magistrate judge had issued a no bond hold on this, given the nature of the charges. Mr. Neal, did you want to be heard on?
We just asked that the court follow the findings of the prior magistrate given the circumstances and to not disturb the current setting.
All right, Mr. Archibald or Mr. Crane?
We don't intend to ask for bond today. We'll bring that up at another time.
All right, thank you. The court will leave the bond set currently with no bail. And Mr. Bronco, I believe you also might have another hold on you for federal charges. So you are scheduled for your court date for your preliminary hearing on March 29th. Is there anything that the court can address for you?
No.
No? Okay, thank you for your appearance today. You can be excused. Thank you, counsel.
Thank you, Your Honor.